As the court pleases, my lord, the matter was postponed today for two reasons. The first reason, my lord, was for the state to furnish confirmation from the Director of Public Prosecutions in South Gauteng regarding the status of Exhibit C. The confirmation has been obtained, my lord, and furnished to the defense this morning. And secondly, the matter was postponed to today for the defense of accused number 5, Advocate Mshololo, to give an indication as to whether or when she'll be able to proceed with the cross-examination after the contents of the second docket, Fossil Res 37541 of 2019, my lord.
Advocate Baloyi, if you were to put me in better light, we are talking of the first, which connotes that there is a second docket. I know that we have spoken about two dockets.
Yes.
Which is first and which is second?
Yes. The first docket, my lord, is the one that relates to the current proceedings. There's Fossil Res 636 of 10 of 2014. And the second docket, my lord, is Fossil Res CAS 375 of 1 of 2019.
Advocate Mshololo told us that she only became aware of the second docket. I think it was Friday, last Friday. You seemed to be saying the same. To say that yes. if not Friday, your awareness of the so-called second docket was at a later stage. And when would that have been?
Yes. My lord, there are two issues: the furnishing of the actual copy of the docket and the awareness of the existence of the docket. My lord, insofar as the existence of the docket is concerned, we want to mention that as early as the 25th of January 2022, that former counsel for accused number 3 had requested further particulars, and he directed a letter to the state on the date And in the first paragraph of that letter, he requests contents of case docket Fossil Res 375 of 1 of 2019. And he mentioned that it was opened and recorded by Colonel Buthelezi and Warrant Officer Makubo. So, my lord, we're saying that as far as the 25th of January 2022, former counsel for accused number 3 was aware of the existence of this docket.
It's 375 of what?
375/1/2019.
Yes.
And my lord, as indicated last week, I wrote a letter on the 23rd of March 2022 directed to the investigating officer, Lieutenant Colonel Buthelezi.
On the 23rd?
Yes, on the 23rd of March 2022. I wrote a letter to Lieutenant Colonel Buthelezi requesting a copy of the docket so that it could be disclosed to the defense. And I gave her the deadline of the end of March to submit the docket.
You gave her what date?
A deadline of the 30th of March 2022 to submit the docket.
Meaning 375?
Yes, 375 of 1 of 2019. And as I indicated last week, my lord, before the end of March, she came to my office with Advocate Tefo, and instead of handing the docket to us, it was then handed only to Advocate Tefo.
Before the 1st of?
I think it was around the end of March, my lord. Don't have the exact date, but it was around the, sorry? Well, Advocate Tefo has just whispered that it was on the 23rd of March. And in fact, at that stage, my lord, indicated to her that if we don't get the copy of the docket, we might consider subpoena duces tecum at that stage, my lord. And as also already indicated, my lord, even the investigating team in this matter don't have a copy of that docket. My lord, we're mentioning all these factors to indicate that, as it was widely reported, that it is not as if this docket has mysteriously surfaced now. And when the accused pleaded on the 22nd of April 2022, Advocate...
I think we should not go into further details.
Yes.
Because I just wanted to know how the chronology of events unfolded.
Yes. But can I just, maybe with the permission of court, just make this one last submission, my lord? When the accused pleaded on the 22nd of April 2022, Advocate Mshololo said the following on behalf of accused number 5, and I quote, "No objection to the transfer of jurisdiction. There is another docket for Solores Case 375 of 1 of 2019. That is according to my note, my lord. If that becomes an issue, we can listen to the record.
That was on?
On the 22nd of April 2022, when the accused pleaded. So they themselves, my lord, place it on record that there is another docket, namely for Solores Case 375 of 1 of 2019. So, my lord, we are saying that already at the plea stage back on the 22nd of April 2022, this docket was mentioned by Advocate Mshololo. We therefore submit, my lord, that no one can assert that they were not aware of the existence of this docket. It was also extensively canvassed in cross-examination by Advocate Tifo. And as I indicated, my lord, on Wednesday last week, that we only got copies, including
I think you are going back to
Yes.
what I warned against. Because,
okay, as the court pleases, my lord, I'll leave it there. So.
my sense is that we are not, I just wanted to know the chronology
As the court
of
pleases.
events. Because I think the ball is squarely in Advocate Mshololo's court in terms of where she wants to take this.
As the court pleases.
Just one last question for clarity from me, if you know, because you seem to be saying that Advocate Tefo was furnished with a copy of that docket, be it on that 23rd or
Yes.
whatever other day, but before the commencement of this
Yes.
proceedings. So it was not you, it was not the state in this case furnishing Advocate Tefo with a copy of that docket.
No, not at all, man. It was the investigating officer.
Yeah. I'm asking that question because in this case there are two defense counsels, and you mentioned only one of them as having been furnished with a copy.
Yes. Indeed, that is so, my lord.
You became aware of that? Did you become aware of that only one of the two advocates has been finished?
Is the court referring to the date of January that,
Yes.
that I mentioned?
Yes.
Well, the state has always been aware of the existence of the docket, my lord.
Okay.
Even before the date.
I'm saying so because only one of the two defense counsellors
Yes.
has been finished with a copy,
Yes.
which doesn't sound right.
Yes. Indeed, my lord, and as I indicated, even the state, we only got a copy on the same date last week, Wednesday, just as Advocate Mshololo got hers.
By the way, last week it was on the,
I think it was on the 8th, if I'm not mistaken, my lord. I'll just verify. Yes, indeed, it was on the 8th, my lord. And perhaps later on, depending on what happens, my lord, would like to get another speaking time to address Exhibit C, my lord, at the later stage.
okay. Advocate Msholo. The first point, I think, is just needs confirmation or denial, which is about the confirmation of the second docket.
My lord, as the court pleases, my lord. My lord, it is not correct to be, just to go straight to the point, it is not correct that on the 22nd of April, I addressed this court and said...
No, that's the later point. Confirmation of the second docket. That's the point that your colleague started with, which he says was done. Was it this morning, Advocate Baloyi?
About the confirmation, is the court referring to the confirmation?
Yes.
Yes. We gave the letter from the DPP South Gauteng to the defense this morning, my lord.
Yeah.
My lord, should I ask addressing the letter that have just been given or the response from what Advocate Baloyi has
No,
made?
what I am seeking to know
Yes, my lord.
is whether you confirm that you were finished with confirmation of the existence of a second docket only, I think you said today.
Yes, just before the proceedings resumed.
Yeah, just
Yes.
today.
Yes, I confirm, my lord. It has just been given to me.
Yes. Now the other part which you were about to speak about when I stopped you, Advocate Baloyi seems to be saying that as far as he is concerned, the defense has been aware of the existence of a second docket. He mentioned a date. Was it the 23rd?
22nd, my lord, when the plea was made in this court.
Oh, yeah. Yes. Yeah. He seems to say that on the 22nd of on the 22nd when your client pleaded,
Yes.
in that process you made mention of the docket number or numbered cast number 375 of 1 of 2019. I think that is the first part of your response.
Yes, ma'am.
Secondly, when we adjourned last Friday, I mean not last Friday, on the 8th, you mentioned that you will need time to be able to determine your readiness to proceed in this trial, given the disadvantage you were put in by virtue of not having been furnished with a copy, by virtue of not having been informed from the word go about the existence of a second docket, and also by virtue of not having been furnished with a copy thereof.
As the court pleases, my lord.
Yes.
My lord, I think we also omitted the should I also address his lordship regarding the letter I've just received from the state
The
in
one
my response?
concerning the confirmation.
Yes, my lord.
Yes.
Thank
You
you.
can start there.
Thank you. My lord, regarding the confirmation that I have received from the State Council this morning, giving clarity of the status of Exhibit C, wherein certain people whose names were read into the record was sought, has been given or has been provided to me this morning, my lord, as per the letter dated
Yes.
oh, my apologies, my lord, there is no date, but it's a letter without a date, without a date stamp, from the Director of Public Prosecutions, Local Division, Johannesburg, wherein he addresses as follows, my lord. Open court, my lord. Clarity sought regarding purported correspondence from DPP South Gauteng in the murder trial, Mr. Senzo Meyiwa, as per Force Laura's case 363-10-2014. Your 10/12/3-P 243/2016 dated 10 June 2022 refers. That's number 1, my lord.
Can you repeat the reference?
The reference. Your 10/12/3-P 243/2016 dated 10 June 2022 refers.
Dated?
Dated 10 June, my lord, 2022 refers.
Yes.
Number 2, this office did not make any decision or otherwise regarding the case docket.
Yes?
Number 3, my lord, the alleged documents do not have any status as such was an internal opinion from a junior state advocate which was without merit. Should I repeat, my lord?
I heard you to be saying that what is communicated is that that office, the DPP Johannesburg,
Yes, ma'am.
regards that docket
As an internal opinion.
and therefore as being of no consequence regarding the matter.
Yes, my lord.
Yes.
Thank you.
Madam, I'm terribly sorry for the interruption. I've just received just now an updated version of this letter. I wonder if we shouldn't adjourn just for a short while so that I can give, there isn't much difference, just one slight issue that has been added. If we adjourn just for 1 minute so that I can give them this updated version, my lord.
When did you receive it?
Just now, my lord. Someone just walked in to hand it to me, my lord. The court can just wait in the corridor.
The court can?
Just wait in the corridor.
Yeah. Okay, so I'll be back shortly, provided no other letter is brought in.
Yes.
my lord. And the DPP South Gauteng is saying, the alleged documents do not have any status as such, was an internal opinion from a junior state advocate, which was without merit. Signed by M.A. Chauke, Director of Public Prosecutions, Gauteng Local Division, Johannesburg.
Yes.
Thank you, my lord, for the confirmation of the status of Exhibit C from the author. Then from now, I will be able to cross-examine on the document because I've got the confirmation, my lord. Thank you, my lord.
Just
Can I move?
Just maybe some comment in passing, you know, because you will remember that your colleague also did say that he might want to mention something. I don't know whether it is now or at a later stage. But from my side, I just want to remind everyone, especially the three of you, of the system in use in our judicial field, that unlike other jurisdictions, France amongst others, as opposed to the inquisitorial system,
Yes, sir.
the bench in South Africa is bound to the accusatorial, if not the adversarial approach.
That's the court business.
And therefore, you will find that I come across as very non-committal in some of the issues that are popping out from the holes, not because of disinterest,
Yes,
but
sir.
I'm bound to adhere to the adversarial, if not the accusatorial approach in our legal system.
Yes,
Advocate Baloyi.
As the court pleases, my lord, there are two issues that the state would like to address. The first one, my lord,
Is it now that you need to
Yes.
do that? Okay.
yes. My lord, the first issue is the assertion by the defense characterizing Exhibit C as a decision of the Director of Public Prosecutions, Johannesburg. I'm not addressing the letter that we've just received, my lord. I'm just merely going on the argument that was advanced by Advocate Mshololo on Wednesday. Exhibit C, my lord, was characterized as a decision of the Director of Public Prosecutions, Johannesburg, to charge the persons mentioned therein
Yes.
My Lord, at best, insofar as this document is concerned, Exhibit C, it purports to be a memorandum by the author.
You say where it regards the charging of who?
Yeah, it purports to be a memorandum.
There's something that I missed.
Oh,
as you
yes,
was-
I'm sorry.
There's something I missed. You spoke
Yeah,
about
I said-
somebody being charged.
Yes, I said the court will recall that Advocate Mshololo read out the names mentioned in the document. It was characterized.
You mean
as-
the charging of people other than the accused
Yes,
in
yes.
this case?
Yes.
Okay.
And my Lord, we are saying at best it purports to be a memorandum by the author, and it's addressed to the Director of Public Prosecutions, South Gauteng High Court, Johannesburg, and page 1 to 3 thereof summarizes the evidence. The author then attaches an unsigned indictment, and here, my Lord, the emphasis falls on unsigned indictment. The author also attaches a summary of substantial facts, as well as the list of witnesses. And my Lord, our submission that at worst there is nowhere in Exhibit C where it is stated that the Director of Public Prosecutions, Johannesburg, has decided to charge any person. We therefore, my Lord, we submit with the greatest of respect that it boggles the mind as to why the defense characterized a mere memorandum addressed by the author to the Director of Public Prosecutions as a decision
But Advocate,
to charge certain
Advocate
people.
Baloyi,
Yes.
that document purports to have emanated from the office before anybody becomes aware of the dynamics you are
Yes,
bringing out now.
yes.
What should I say? Should I say even I would have been forgiven
Yes.
for thinking that this is an official document, but which did rounds within the office of the DPP, South Gauteng. And therefore, if anybody says that without the clarity you have given,
Yes.
can we go and blame such a person?
No, I'm saying, my Lord, apart from this document that we have received this morning, just on a cursory perusal of this document, that it does not purport to be an instruction, as it was argued by my learned friend on Wednesday on behalf of.
Yeah, but I also think in that regard you may well be hitting a dead snake
Yes.
compared to what Advocate Mshololo just told us.
Yes. Yes.
From what I heard, she said that having been clarified,
Yes.
she is of intent to proceed.
Yes.
To proceed from where she had left.
Yes. We'll be coming to that point, you know, at the later stage. I'm just saying, even on Wednesday, there was no indication, just by a mere glance at the document, there was no room to argue that this is an instruction. And, my Lord, the reason why I'm saying this is that you'll recall that the state was castigated as having thrown these proceedings into shame, my Lord. This is the point that we're making, my Lord, that assertion, my Lord, by Advocate Mshololo was incorrect, was erroneous, and we request that it should be withdrawn, my Lord.
Advocate Mshololo?
My Lord, I think the court also does have this exhibit. If I may ask it to be given to the court so that we can read English.
Was it?
Can you give it to the court?
Advocate,
Exhibit C.
I think the secretary is not here. I don't know where can somebody lend me a copy of Exhibit C?
I've made some notes, but it doesn't really matter. I don't think there'll be...
Show her the notes.
Sorry, okay, can I then have it back? Sorry.
No, I just wanted to show Advocate Mshololo the notes.
Oh, I'm sorry. Okay.
In case she thinks you wrote a message alongside.
Yes, my Lord.
And I think in that regard, the notes should also be shown to Advocate Defo.
Thank you, my Lord. That side.
What do I have to look at?
Notes. I said notes. There are notes.
Yeah.
Yes.
Thank you, my Lord. Can I start, my Lord?
Yes.
Thank you. My Lord, before, initially, as the court has just alluded to that, effect that I indicated specifically to say, my Lord, this document is unsigned. And as a result of that, before I can be able to cross-examine on this document, I will need a confirmation from the author, my Lord. That's what I said before I started my address, my Lord. And then I said the reason why I need the reason or confirmation from the author, my Lord, it's because there are names on page 3, my Lord. 1, 2, 3.
Yes.
It's because there are names referred to on page 3, my Lord, which I would like to read together with this court so that we can understand English here. It says the Director of Public Prosecutions for the Gauteng Local Division of the High Court of South Africa, who prosecutes, my lord, for and on behalf of the state, hereby informs the Honorable Court that the following people, the names, my lord, I read into the record. And I'll jump the names, my lord, and go to the second page wherein it says, are guilty of the following crimes. That's a decision, my lord. Are guilty of the following crimes.
Despite it having, it being unsigned.
And my lord, I was not saying it's a valid document. I was just reading as is, my lord.
You are saying that's how it came across to you.
That's how it came across to me, my lord.
I think that's what I said this as well.
Thank you, my lord. I just read it as is, my lord.
All right, okay.
And therefore it cannot be said that I said wrong things, that the decision is made by the DPP when I read the content of this exhibit as is, my lord, and I was trying to base the reasons why I need confirmation from the author, my lord. And as I have received the confirmation from the author this morning, I have accepted and acknowledged it, my lord, and I said I will then now be able to cross-examine on the content of this. We are still going to cross-examine on the content of this.
Yes.
Thank you, my lord. My lord, can I proceed with the
Yes, please.
further answers the court wanted me to respond? My lord, regarding the knowledge of the second docket, which is Foslorus 37501-2019. My lord, the state indicated that they were aware of this docket by January this year. And from the state submission, my lord, there is nowhere in the state is saying they informed me regarding the existence of such docket. My lord, the state further informs this court that on the 23rd of March 22, he directed a letter to Lieutenant Colonel Buthelezi requesting a copy of the docket, which was never given to him, but it was given to my learned friend, Advocate, therefore in his presence. My lord, I was not present during that exchange of the docket, which is the second docket.
Yes.
And the state is informing this honorable court, my lord, to say the docket was not given to him, but it was given to the defense counsel. After that, the trial started, my lord, on the 11th of April. When the trial started, the state had not disclosed to me the existence of this docket. And now the state is lying to say, I said to this court, I know about this second docket. And I will ask my lord that we do a transcript for the appearances of the 22nd of April, wherein a plea was made on behalf of the accused. The only thing that I consented to, it was the letter of the Director of Public Prosecutions regarding the jurisdiction of this court having to try this matter. And my lord, to say I knew about the existence of this docket, does that mean that I was given that docket? Or the state is just shifting the blame now? The state had a duty, my lord, in terms of accused number 5 constitutional right to disclose this docket to me, and they had not done that.
Yeah.
And the explanation, my lord, that is given by my learned friend, with due respect, my lord, is not acceptable. To say the docket was not given to him. He was also, the state was also denied access to the docket up until this trial started, wherein the state ought to have compelled. The state could have sought for an order, my lord, in this honorable court, compelling the SAPS to deliver such docket. So in other words, the NPA failed to control SAPS regarding the access of this docket. They were also denied access to this docket. Is that what this court should believe, my lord? I submit, my lord, that that is not the position. The SAPS opens the docket, and after opening the docket, they take it to the DPP. The DPP is the one who is vested with powers to supervise investigations, to control the docket, to demand the docket as and when the docket is required. And before the trial starts, my lord, if there is any other docket which was opened regarding one case, the state prosecutor, even a junior, my lord, is supposed to collect all the existing documents, whether they were declined or whether they were referred to alternative dispute resolution. But the procedure within the NPA is that all the dockets have to be collected and combined in one docket so that they can be disclosed to the defense before the trial starts. And now the prosecutor, my lord, here is shifting the blame as if the docket had been disclosed to me before the trial started, which is not the position, my lord. I am the one, my lord, who engaged with Mr. Baloyi after seeing the second statement of Mr. Mosia. I asked Mr. Baloyi personally, my lord, to confirm if this docket does exist, and he confirmed. Then I said, please, can I have the full content of this docket? That is how it came to my attention. I have no reason, my lord, to hide before this court if the docket had been given to me. I had no information about this docket when the trial started. And what makes the things worse, my lord, the state allowed me and accused number 5 to plead when he had not been furnished with adequate information regarding this case. My lord, without telling this court or disclosing the information contained in the second docket, but it is about the same cause of action that you are dealing about in this matter. It is about the same count that you are dealing about in this matter. So as a result of that, my lord, the state had to, and the state had a legal duty, my lord. It is not a favor. Accused number 5 constitutional right has been violated to such an extent that, my lord, had we known about the existence of this docket, we will not have pleaded as we have pleaded. And right now we are in a predicament that we are unable to conduct our defense further as a result of this late disclosure of the police docket. The state knew about this docket, my lord, and neglected or decided not to disclose it to accused number 5, and thereby violated the accused number 5 constitutional right. And that on its own, my lord, amounts to a miscarriage of justice.
Yes.
From day one, I received the docket. I informed this honorable court about the existence of the docket, which was last week, the 8th of October, or the 8th of June, my lord, 2022. That was the first time I received that docket from the state. And that's a non-disclosure, my lord, by the state. And the state is not the one who is going to suffer the prejudice, my lord, by this non-disclosure. It is accused number 5, whose constitutional right has already been violated. And his right, accused number 5, right to a fair trial, has been violated, my lord. That is why, my lord, I'm saying the reason furnished by my learned friend is not sufficient to say he was also not given a docket, but it was given to the defense for accused number 1 to 4. The state should have compelled the SAPS to produce this docket.
Yes.
Regarding, my lord, the second part of the response to say how long do I need, as I have suggested, my lord, after receiving further particulars during trial, I still need to request for further particulars from the state. And after that, we still have to do a pre-trial conference and also deal with the admissions thereon. There are particulars that are not contained in this docket. It has been sifted. And I need to clarify all those issues, my lord, with the state.
Yeah.
As I have indicated, my lord, last week, that the remaining period, which is today up until Friday, which was the date for the date in which we were supposed to sit in this matter, are insufficient, my lord.
Yes.
And therefore, I will ask that the matter be adjourned, depending on the dates that we get from the role coordinator, my lord. Then we will be able to come before this court. If the dates available from the role coordinator are too soon, I will then indicate, my lord, if they are insufficient. But if the dates given by the role coordinator are maybe at a later period, I will indicate, my lord, to say they are suitable to me. And my lord, I ask that an order be made that the transcript for the 22nd of April be done to prove wherein my learned friend says I said I know about the existence of this docket. And above that, my lord, knowing about the existence of the docket, it's something else. Section 87 does not say that the state has to inform the defense about the existence of the second docket. It says the state must disclose the information, including the statements contained in that docket. And that was not done by the state in this matter. Which amounts to a miscarriage of justice, my lord. The trial is now going to be delayed because of the non-disclosure of the state. The trial is going to be delayed because accused number 5 rights have been violated. And the violation is incurable, my lord. I will address at a later stage regarding that. I still want to deal with the docket that I've received before I can be able to come back before this court with the appropriate application as the court pleases, my lord. sure if the addresses are not supposed to be interpreted to the accused.
Yes?
Sizozama-ke bafethu kuloko okuningi esekushiwo-ke. Ekuqaleni-ke umshushisi noma yena-ke u-advocate uSibiya my apologies, u-advocate uBaloyi uyitshelile-ke le nkantolo lena mayelana nesinqumo noma isizathu esibangele ukuthi kwiveki elindlule ngolesithathu singaqhubeki bese liqala lihlehliselwa namuhla bekuwukuthi-ke amadokodo noma idokodo lesibini eliwu-3751 ka-2019 kanye-ke nencwadi ibisicelwa uyena ummeli wakhe ummangalelwa wesihlanu u-advocate uMshololo. Incwadi leyo-ke abayitholile kusasa namuhla naye-ke wase endlulisela kuyena-ke u-advocate uMshololo mayela naleli dokodo lesibini eliwu-3751 ka-2019 mayela nesinqumo esathathwa-ke kwinkantolo ephakeme eyase-South Gauteng eJohannesburg. Futhi-ke kusho-ke u-advocate uBaloyi ukuthi naye-ke idokodo noma ikhophi lalelo dokodo lelo ulithole ngokufanayo naye u-advocate uMshololo ngolwesithathu weviki elendlule, idate kwakuyi-8 kaJune kulo nyaka sikuwona u-2022. Okwesibili-ke noma okunyeke okuveziwe khona lana-ke ukuthi u-advocate uMshololo ubeseyitshela-ke inkantolo ukuthi weneme-ke ngoba-ke usitholile-ke isiqinisekiso noma-ke lokho okubhaliwe kwincwadi ebuya khona-ke eSouth Gauteng la basho khona-ke ukuthi isinqumo esathathwa khona-ke noma-ke bona-ke bengamele ezokushushisa eSouth Gauteng beyiqhelanisa nesinqumo esathathwa khona lapho ngoba bethi-ke lokho-ke kwakuwuvo lomunye wabo osebenza khona lapho futhi-ke abantu uma bemchaza-ke bathi uyi-advocate ejunior-ke kunabanye ukuthi-ke kumangalelo noma-ke kujeziswe noma kushushiswe abantu amagama-ke afundiwe kwiveki elendlule. Futhi-ke nala khona-ke ngokusho kwakhe u-advocate uBaloyi ukuthi la kuchazwa noma okwenzekile khona laphayana-ke ukuthi leya ncwadi-ke kwakuyincwadi engasayindiwe ukuthi nje bayichaza ngokuthi yimemo kodwa kungesona isinqumo esathathwa ihhovisi labengamele ezokushushisa eSouth Gauteng. Kodwa-ke uthe uma seyiphinda sechaza-ke u-advocate Mshololo lokho wachaza ukuthi ngendlela yena-ke ebechaza ngayo noma ekusho ngayo la enkantolo kwiviki elendlule wayefunda lokho okubhaliwe khona laphayana ukuthi ihhovisi elengamele ezokushushisa eSouth Gauteng eJohannesburg lithathe noma kuthathwe isinqumo sokuthi kumangalelwe futhi-ke kuboshwe laba abalandelayo ase amagama abo efundwa-ke. So uthi yena-ke abekwenza ukuthi nje ebechaza lokho noma efunda lokho ekubona kubhalwe phansi kwi-document ebuya khona-ke ku-DPP. Kodwa-ke evumelana-ke naloko kushoyo yena-ke umshushisi ukuthi kuyi-document engasayindwanga noma engekho umuntu oyisayindile futhi-ke kanye namagama lawo echaziwe khona lapho-ke. Wabesesho-ke emuva kalokho advocate Mshololo ukuthi manje-ke ngoba esetholileke leyo ncwadi emphendulayo useyimisela noma usekulungeleke ukuthi angaqhubeka-ke kodwa aqhubeke nokuthi abuze imibuzo yakhe kanye ngokuphathelene nakho khona lokho. Okunye kuveziwe-ke uyena-ke umshushisi ukuthi-ke ngedate yange-22 zika-April kuwona lo nyaka uma ngabe nanibuzwa-ke ukuthi nithini kumacala enwethweswayo wathi umshushisi-ke u-advocate Mshololo wavuma-ke phambi kwale nkantolo ukuthi-ke unolwazi lwalelo dokodo. Kodwa-ke kube khona-ke ukuphikisana lapho-ke engakuvumi-ke u-advocate Mshololo kodwa ethi uyacela-ke ukuthi kuko konke lokho noma kuma-recordings alelo langa lolo kulethwe-ke ngaphambili kusho ukuthi kuyikuphi la asho khona-ke ukuthi yena-ke wayazi ukuthi lelo dokodo likhona. Okunye kushiwo ngumshushisi ukuthi-ke u-advocate uTifo-ke uyena umuntu kuphela owathola lelo dokodo lelo yena-ke umshushisi angazange alithole nanjengoba eshilo ukuthi uthole kuleli viki elendlule. Into-ke leyo athi-ke u-advocate Mshololo wayengekho-ke yena ngalelo langa wayengeke azi-ke ukuthi ngubani walithola futhi-ke kuwubani ongazange alithole. Usecela-ke futhi ukuthi kulabo-ke abahlela amalanga ukuthi icala-ke liqulwe sekuzobonakala khona lapho ke ukuthi yiliphi ilanga elizothi icala lihlehliselwe lona ukuze ashoke ukuthi ukulungele yini ukuthi aqhubekele phambili noma kuzobonakala ukuthi i-date esondele kakhulu. Okunye futhi akuvezile uadvocate Msholo ukuthi ke bengeke ke noma ngoba leliya dokodo leliya noma lesi sinqumo lesiyana sasiphuma ngaphakathi ke kwihhovisi labezoshushiso ngeke ke noma ke kuyi-junior advocate noma ubani ke ayahlanganiswa amadokodo uma ngabe ehlukene abe ndawonye kube yila khona ke kwenziwa idokodo elilodwa. So ukuthi ke kwakuyi-junior advocate lokho akusho lutho, naye ke uyakwazi ukuthi ke lokho angakwenza ngoba esebenza kuleliya hhovisi. Futhi ke kube uyena umuntu oyicelelayo ku-advocate Baloyi emuva kokuthi ethe wabona istatement sesibini noma istatement sesibini sakhe uSergeant Musiya kwawuyena ke omcelayo ukuthi ke asesikhulumeke noma siboneke ukuthi le dokodo leli lithini. Futhi ke uma ngabe lokho bekuyinto eyenziwe ngaphambilini kokuthi ummangalo wesihlanu ayiphendulele kwinsolo ayibekwayo bebengeke bayiphendulele uma ngabe bebazi ukuthi kunedokodo lesibini elikhona ke. That's a summary, my lord.
Yes, please the court, your lordship. I'm worried, your lordship. I'm at court today. It seems I'm not recognized. I'm here. Can I be recognized?
You are recognized.
Thank you. Your lordship, I want to make an address to the honorable court. However, I see that the time is not on my side. Can I address this honorable court after tea time?
Okay. Will adjourn until past.
Yes, it is the court, Your Lordship.
Here we say your lordship, not your worship.
Lordship.
Yeah,
What did I say?
your worship.
Apology. Apology is a slipper of the tongue, which is not the fault of my mind. In reality, I wanted to say Lordship. And you are Lordship. Justice Maumela. Thanks for indulgence, Lordship. I heard my learned colleagues from the state and from the defense accused 5. Then I'm happy that I'm now recognized.
No,
Lordship.
you are harping on about recognition. You were recognized the moment you introduced yourself. Maybe I should sensitize you to one thing. You always sit behind that block and you go lower.
Okay.
I always presumed you are there until one day we were proceeding and you walked in. when I knew you to be in court. So you are recognized. It's just that when I can't see you, I can't call you because I can't see you. From the beginning of this trial, you hide here. I don't know what is happening.
And I was not intended to hide, Your Lordship. Thanks for realizing.
Yeah,
for
if
making
you
me
come and
realize
sit here and ask somebody to sit there the way you sit, you'll realize that you see nothing.
Definitely.
Okay,
Yes.
let's proceed.
No, I'm aware now. Thank you. Your Lordship, in relation to the concern of my learned friend, Advocate Mshololo, in response to what she raised previous on the last adjournment, which was Wednesday, whereby I gave the court excuse, but my attorney was there. So is that I understand that she asked, I cannot use a heavy weight to say demanded. She asked the state via Advocate Waloi to get explanation insofar as Exhibit C and D were concerned. Exhibit C and D, Your Lordship, are brought, or is the part of the submission of accused 1 to 4. And the purpose of Exhibit C in particular, because it is the one that is the one that triggered the request of explanation for the certain individuals who were mentioned by the names. And at the time when I was introducing the document, Exhibit C, the names were mentioned that these people were supposed to have been charged instead of my client, accused 1 to 4. And by that time, I vividly remember, I didn't just confine to accused 1 to 4, but I said all accused, including 5, that they are wrongfully before this court. And the relevant suspect who should have been arrested and prosecuted by Advocate Waloi are those on Exhibit C. Instead, they were not, and I wonder why. Then, what purport to be the explanation of the DPP? Advocate M.A. Chauke, South Gauteng. There are two documents here. We were first given this document. The subject is about phosphorus cast 636/10/.
Yeah, if you were not to
2011
if you were not to repeat that, we all know it is common knowledge that there are those two dockets. If you go straight to your point.
And today, Your Lordship, humbly so, because there is no Messiah here to be cross-examined, I'm begging this honorable court to afford me opportunity to make submission to the best of my ability without interruption. That's my humble plea. And I'm going to repeat a lot of things.
Our fight, advocate, therefore, is when you repeat things that are already common knowledge.
Your Lordship, I'm not fighting with you, and I'll never fight with you.
I'm also not fighting with you.
Maybe the word fight is wrong.
Yeah.
Can you withdraw the fight? Because I'm not fighting, and you are not fighting.
I'm not. I don't think I should withdraw anything. You are the one who came with the word fight, and I said I'm not fighting with you, and I will never fight with you. This is not about me and you, advocate. Therefore, it's
Exactly.
about other people.
Exactly.
There's no need to fight.
I agree, 127%.
And I will give you time, but when I feel that you are repeating, I will raise my concern, like I do with everyone.
No, it does not happen to everyone, Your Lordship. It happens to me.
Okay.
That's why I'm saying today, I'm pleading. There's no one who can say I'm hurrying to cross-examine Messiah. So today is for this day, for us to talk about these issues.
It is definitely not a day for repetitions. It is a day for submissions. That I will allow you to do. You can submit on end until the evening. You can do that.
So this document, Your Lordship, my learned colleague, Advocate Mushololo, as per her request, it seems that she has accepted it. This document, like I said, initially that's where I was interrupted when I was about to say the first one. That's where I was interrupted. Hence I say, that's my plea today. Let me be allowed to exercise my talent that God gave me.
My
to do
plea
everything.
today,
Yes.
avoid repetitions.
So, this one, I don't know how do we, for the purpose of progress and the court and everyone listening here and watching and Skype and everything, wherever overseas, we know we are watched everywhere. This first one, I'll call it the document, the subject is a 636. And then this one was correcting it, it's 375. This came late. So I start with this one, 636. Even though it was not my
Are you
request.
aiming to do that now?
Pardon?
Are you aiming to do that now?
Yes,
No,
yes.
you can't do that now. Advocate Nshololo
Yeah.
raised issues which prompted these documents, these two documents you're talking about,
Yes.
to come before court. When, after advocate, earlier on, I did say we will also need to listen to you. Then advocate Baloyi gave some background issues. Advocate Mshololo told this court, because she's the one on the podium now, that she is still to come with an application. I haven't heard, unless I missed something, I haven't heard Advocate Mshololo's application.
Let me correct the court.
And now you are addressing me on issues that hinge on issues that may affect the application. And after her application, you will be given an opportunity to address
The application.
before the state responds. Because if I now jump from people without dealing fully with what Advocate Mshololo is bringing, it will confuse me as well.
Application, what is the court referring to when say application?
The advocate Mshololo spoke about a proper application she's bringing because of the two documents. And now, before she brings that application, you are rising, addressing me on the two documents that form the basis of the application. Advocate Mshololo told me this morning in your presence, if you were present.
Application to postpone this matter?
Yes.
Yes. That's where
And my sense was that if she brings the application, advocate therefore must really be given an opportunity to say his say, respond, oppose, or agree, whatever. Now you said you want to address me, and to my surprise, you are addressing me about what Advocate Mshololo is still to come up with.
Yeah. Because I've stayed here for a long time, giving Advocate Mshololo the opportunity and my learned colleague, Advocate Baloyi, because they were owning the podium on Wednesday, and then that's where we are today, to extend that the matter has been postponed to today, whereby we are also the part of the proceedings.
But now,
So now
you
I
sound to be responding to an application yet to be made by your colleague. I cannot listen to your response before I hear everything she needs to say. How will I be able to place what you are going to tell me before I listen to her?
Because there are certain issues that I need to object, Your Lordship, which are not correct. And
Yes,
somebody said...
You will have that time to object if they have to do with this.
No.
Unless it's something else that has nothing to do with those documents, then you can speak.
I don't need this to come to that so-called application. I need to respond now, because if I can let it until that application, so I will be just if we object, we objecting to say no. That
No.
application cannot be,
No.
because there is a precipitation towards that application, and then myself or accused 1 to 4, we see the prejudice already before we can go far. That's why I say I don't let this to go far.
But that
I have
doesn't
to come
give you
in now.
It doesn't give you the right to kick her out of her space. She's still going on with these issues. When she's done, I will give you the opportunity.
I want to believe that if I cannot come now, it will be that what Advocate Baloyi said, for which it was not me, Advocate Mshololo said, he is lying. I'm not on that vocabulary to say Advocate Baloyi is lying. What I'm saying is that Advocate Baloyi misled this court. So that's where it's now opportune for me to come in here.
We
go to the application.
In this court, it is not opportune. In this court, it is the opportunity for Advocate Mshololo, given the chronology we have had and the response, to go and prepare herself and come and launch her application. This issue is still underway, and you cannot uproot me from concentrating on what your colleague is telling me. You are there. You are free to listen, even to note down if you want to note. This matter shall never be decided without you being given an opportunity to address. It is not now, if those are the issues.
Okay. Or it may not be now, but it's today.
It may not be. It may not be today. It depends on what Advocate Mshololo is going to show as the way forward.
No,
It doesn't have to be today.
No, Your Lordship. I need to be heard, be given a hearing. I'm finished. I haven't even started yet.
I will listen to you
I haven't
until
even
the evening,
started.
and as long as it
Unless-
has nothing to do with that application that Advocate Mshololo is still to come up with. She has been requesting and pleading for days to be given an opportunity to launch her issues before court without disturbance. I have thrice apologized to her for the disturbance. And unless this is something else, it is another disturbance of Advocate Mshololo to tell us she spoke about going to study the papers further, about consulting further. The problem that I have, which I also had the other day, is that when Advocate therefore thinks it's time for him to speak, or thinks it's time for the court to pronounce 1, 2, 3, it must happen. And that's not how things happen.
I never said that.
The other day, I had to warn you when you were demanding that the court should go a particular direction. And I'm saying now, as the presiding officer in this case, it is time to give Advocate Mshololo the opportunity to proceed with what she started in your absence, but you had left your ears, as you always say, you leave your ears here. And she is not done.
Can my attorney address before?
Yes.
You want to?
Let him address.
There's a court, please, my lord. Maybe I'll come to the assistance, Your Worship, my lord. Advocate Mshololo,
Yes.
my lord, admitted these 2 documents. She accepted them.
Yes.
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 Her application is something else. Now, my instructions to my advocate is to deal with these documents because Advocate Mshololo already acknowledged them and she accepted them without raising any issues with them.
Advocate Mshololo, are you done with this? Are we not going to hear from you about these papers anymore until the end of this trial?
I'm not done, my lord, as I indicated.
My lord, Advocate Mshololo said she will make an application.
Yes. Based on those 2 papers. And I want to listen to Advocate Mshololo and deal with what she has to say. And if the 2 of you want to bring issues based on that, the time is still open. And I'm refusing to be dragged into what you are bringing before I finalize that. I don't want my record to confuse even myself.
I agree with the court. Thank you very much. Because the reason why my advocate was standing up, my lord, is because it was not clear from Advocate Mshololo what kind of application is she's going to make and based on what. Now she's clarifying that she's going to make application based on these documents. Therefore, I think based on that, I'll advise my advocate not to address the court based on these documents, and then maybe we hear from Advocate Mshololo whether she wanted postponement to make that application or what.
Yeah, she gave an indication. She has already told us. She told us that she is going to study further what she has. She is going to consult further with her client. And she'll then decide what nature of an application, if any, she will bring. When she is done, all these issues, including those documents, you're on behalf of accused number 1 to 4, you'll have all the space to address court.
You know, my lord, the reason why we stood up is on the premise of the submissions made by the state,
Yes.
which we differ
Yes.
with that submissions.
You have.
And that application of,
Yeah.
of Advocate Mshololo is not based on the submissions made by the state because her application is based on these documents. Whatever Advocate Balwe addressed the court about today, Advocate Mshololo did respond on that.
But I keep on saying to you and your colleague, don't uproot me from what Advocate Mshololo. Things have disturbed Advocate Mshololo. Please don't disturb me. I'm listening to Advocate Mshololo. When I'm done about the issues she has put on the table, you will have all the space in the world to come up with your own issues, if you have your own
Basically,
issues.
my lord, you're saying we must sit down and Advocate Mshololo must proceed for now.
I don't know whether she'll proceed.
Thank you, madam.
That's what I've been saying from the beginning. I've been saying that from the beginning.
Your Lordship, just for the record, the reason we need to address this is because of the defectiveness of these documents. So if Advocate Moshololo is going to address this court in terms of her application based on this, let it be on record that she will be addressing that application on the defective document from the DPP.
If those documents are defective today on the 13th of June 2022, even on the 31st of December 2022, they will still be defective. So it will still be open for you to address the defectiveness without interjecting Advocate Moshololo in her process. She started a process from last week. She's busy with it. We cannot have something in between without undermining Advocate Moshololo and her client.
No one is undermining Advocate Moshololo, Your Lordship. And what the imperative thing, the material issue is that the document that Advocate Moshololo is also talking about, as I said, C and D, are the brainchild of accused 1 to 4. So they've got nothing to do with Advocate Moshololo.
I think I have given enough explanation. I now come to rule. The ball is in the court of Advocate Moshololo.
Let us
Whoever has something else will address me later, even if it's on another day.
Thank you.
Advocate Moshololo, you did indicate that you are going to look at everything that
Yes.
has been brought your way, including the docket. You did indicate that there's a possibility you might need to consult with your clients.
Yes, the court pleases, my lord.
And you did say, if I heard you well,
Yes.
that based on that, you will consider
Yes.
what nature of application.
The appropriate one.
Yes.
Yes, my lord.
So is that your final position?
Submissions, yes, my lord.
Yes. And when is that application coming?
My lord, it's not today because I still have to consider, I have to read, I have to consult. And then we can arrange the dates with the role coordinator, my lord, but it's not today.
I think you did mention the role planner.
Yes, my lord.
And I think what I had thought I would have is the responses of your colleagues about
Yes, ma'am. Yes.
consulting with the role planner and everybody involved. And also possibilities of enrolling this matter in a manner that will assist
Yes, my lord.
speedy finalization.
Yes, my lord. I'm indebted to the court, my lord. As the court pleases.
Advocate Baloyi, what I hear Advocate Moshololo saying is that emanating from the documents we have been shown today, the 2 letters, also emanating from the second docket that emerged, for my purposes, I became aware of it last week. She intends to study everything further. She intends to consult with the clients further, and it's my own way of putting it. She cannot rule out an application based on everything that has emerged, and even the application as she sits there, she doesn't know yet what nature of application it shall be. Yes, your comment?
Yes, as the court please, my lord, as far as the request for time to consider the second docket, first letters 375 of 1 of 2019, the state has got absolutely no objection, my lord. I think it's, we've made it clear, my lord, even on Wednesday, that she can get as much time as she wants. We are not going to object against postponement as far as that is concerned, my lord. As far as the letters are concerned, my sense was that, and I don't want to misquote here, but that, they're being accepted. I didn't think that there are further issues, that are being raised.
I think there's a rider there. Let us not delude ourselves. There's a rider she put
Yes.
that she's going to look at everything
There's a good
else.
places. Yes.
And based on that, she reserved her right to consult her clients further. And she said, based on that, she will still come back to court with, she feels that there might be an application of a nature she cannot tell now.
As the court pleases, we'll then hold back on our submissions regarding this letter until such time as the
The application,
application is brought, my lord. And it hasn't been officially handed up. I wonder if maybe we should not officially hand up the letter. It has been read into the record, but I think in light of the debate that has been generated regarding the First Lawrence 375 of 1 of 2019, I suggest that the letter be officially handed up, my lord.
Advocate Mshololo,
As an exhibit.
you read two letters. Actually, you read one and you were interrupted by the second letter.
As the court pleases me.
The thinking on the part of your colleague
Yes,
is that these letters be handed into the record.
into the record, but I think we need to submit the last one, which is the corrected version.
We don't know.
We don't know.
We don't know whether Advocate Tefo will confine himself only to the second letter.
Secondly.
When he was addressing me, he was waving both letters to me. So I will be apprehensive in trying to close the first letter out.
My lord, with that, I will ask that we submit both letters, which I've also read into the record. I think we were last on Exhibit D, if I'm not mistaken.
Yes, in light of the fact that the letter pertains to Exhibit C, my suggestion would be that we hand up both letters as Exhibit C in brackets 1. As far as both letters are concerned, my lord.
So we can mark it as Exhibit C1 and C2.
Yes.
Thank you, madam.
Advocate, therefore, the suggestion to admit the letters as C1 and C2, Exhibit C1 and C2, what is your response?
Objection, Your Lordship.
Yes? Objection?
I say objection because I'm coming to object. These two letters are subject of my dispute insofar as the contemplated application will be coming. And it is clear that somebody is trying to make a fishing here. I didn't even make my submission in relation to these two letters, as I allege that there are serious material defects on these letters.
And you have seen them,
Yes, they are here.
and you don't want me to see them? Because they are submitted into the record so that when they are debated, I also have sight of the letters.
But I wanted to raise this and raise those defective. So now,
No.
now I'm told.
The defectiveness of, or
Can I
otherwise,
respond, Your Lordship?
I
You
made
asked
a
me to
ruling,
proceed.
I made a ruling, Advocate Tefo, that we are not going to debate what we are raising now.
Should I not answer you?
Answer me about whether you agree with them being submitted as exhibits. That's the only issue.
No, but it's unfair for the court to confine me.
Okay, that is the only
It's
thing.
rather that there must be answer written there. Then I must see that answer by the
No.
court.
No.
I've got my
No.
answer different to the court.
No, I'm not going to allow that. I'm
So
I'm
why
not
am
going
I
to
asked
allow-
to stand up?
Huh?
Why am I asked
I
to stand up?
asked you to address me about the submission of the letters as exhibits, so that when they are debated, I have seen them. I have gone through them. That is the only issue. Now you are going back to an issue about which I have made a ruling.
You see, what has been done here by Advocate Baloyi and Mshololo, Advocates Baloyi and Mshololo, is that, hence I'm saying, I see some fishing because they don't know which side will Tefu come, which angle. You see, there's like, I'm the strike, I'm number 9.
Advocate, I rule that you sit down. You are not addressing what I asked of you. Sit down. Advocate Baloyi, if you want to submit the exhibits, that's the time to do it is now. But you two, I don't know what you are testing in me. I don't know. What manner of demeanor is this?
I'm trying to help the court.
Yeah, but you allow your friend to drag this court out of its course, only later to say you want to help.
No, my lord, I apologize for that. I understand.
Dragging down because he's delaying us.
My lord, I apologize for that. Hence, we are saying we accept them being marked as C1 and C2. That's why I advise my advocate that in being marked C1 and C2. That's it.
Thank you, Mr. Towan.
Thank you, my lord. The letter dated the 10th of June 2022 from the Director of Public Prosecutions, Gauteng Local Division, Johannesburg, is marked as Exhibit C1. Letter dated 13 June 2022 from the same office is marked C2 and handed up as Exhibits 1.
Thank you, my lord.
By agreement, exhibits C1 and C2 are admitted into the record of the proceedings of this case.
As the court pleases, my lord.
Yes?
My lord, what remains now is to arrange the date for the next proceedings of this matter. And I suppose, my lord, that we will first have to get an indication from Advocate Mshololo at that future date what the plan is going ahead. So perhaps we should, I suggest maybe we postpone it just for a week or so, just to get an indication, and we can then take it from there. The role planner had tentatively given dates, but I think we perhaps need to discuss them with my learned friends. The first dates that I have is the 5th to the 16th of September, and the next dates are from the 14th of November. maybe we can just adjourn so that council can then
14th
Check-
of
check-
November
check.
to when?
check their diaries. I'll just quickly check.
14th of November until when?
I'm just quickly checking, my lord. Sorry, 4 to 14 November. And 5 to 16 September.
The 4th to the 14th.
Yes, the 4th to the 14th of November, my lord.
Because it's issues that have to do with what you have raised, Advocate Mshololo. What is your response to the suggested dates?
My lord, both dates are suitable to me. If we choose the first one, it's suitable, my lord, as the court pleases.
Advocate Tefo?
Your Lordship, I still feel grief as accused 1 to 4 that we are definitely being excluded from these proceedings by this court. Because
Okay.
there are very,
Okay,
very
if you are
material
not going to
issues.
respond to what I asked you, sit down. Sit down, Advocate Tefo. If you are not going to address dates, sit down.
I cannot be forced.
Unless you want to be in contempt of this court. I asked you a specific question. If you are not answering me on that, sit down.
Your Lordship, the best way, let's go to the chambers.
No,
Finish
I'm
it
not
up.
going to the chambers.
But
About
you
you
cannot
trying
allow
to
this.
undermine me in court. I'm not going to any chambers.
But now the accused 1 to 4 has been undermined here. We
Sit down,
cannot
sit
proceed,
down.
we cannot prolong this this case.
Sit down.
Yeah,
Advocate, sit down.
but I don't agree to that.
Advocate Baloy, there is no agreement about the date. I suggest that we find a preliminary date to which we postpone without the involvement of the court, but with the involvement of the role planner. You will go and agree upon dates, but let's have an intermediary date.
Yes, my understanding was that Advocate Mshololo falls in with any of the dates. She said,
Yeah.
yes.
Advocate Tefo disagrees.
Okay. Well, perhaps we should just adjourn to see if we can't find then a middle course.
For how long?
The issue of dates can take time. I suppose council, I'm
I
sorry.
think, my lord, we can adjourn until after lunch, so that you can arrange it during lunchtime.
What time is it now?
It's 12:15, my lord.
All right.
Mr. Baloyi, I see a tablet here which was not here before. Is there a reason why it's now here?
So what's that, my lord? Tablet.
Tablet. It was not here from the morning. Now it is here.
It was placed by someone, my lord, that lady. Stand up, it was placed by that lady, stand up,
Come again?
take that tablet.
It was not here in the morning. Why is it now here? Did you arrange with the secretary? Next time when you plant something, plant is not the word, when you bring something, sorry. Next time when you bring something which was not here, make us know so that we don't get surprised and react unduly. Advocate Baloyi.
My lord, we did have discussions about the dates. The royal planner has indicated that the third term is already full, my lord, and that those dates that we've already provided are the only dates, my lord. We've been given the option of blocking both dates so that we continue on both dates, the 5th to the 16th of September, and we continue again from the 4th to the 14th of November. However,
Because that's what I wanted to say, that the way things work out here, each time you don't occupy dates,
yes,
you fall into the risk of
Yes.
going further into
I-
the future.
indeed, my
And
lord.
what we said, or what we seemed to agree upon, all of us, was that if possible, we should find a speedier way as opposed to a slower one to proceed to finality with this matter.
Indeed, my lord. We will also inform that the first term next year is still open for that block booking. Should we want to go into the
If possible, that should be the way to go. Otherwise, we'll have this matter proceeding forever. And like I said, my worry is that some are not coming from home, coming for this trial. So if the period is too protracted, it will start painting a very negative picture on everything.
Indeed, my lord. Advocate Tiff has indicated that she would like to address the court.
Simply the court, Your Lordship. We wish to come and see Your Lordship in the chambers. We requested the councils. Advocate Baloyi was amenable. Advocate Mshololo blatantly refused to come to the chamber. Hence, we cannot come while we are not in agreement, all of us. Hence, forthwith to address, the intention was that, Your Lordship.
The intention
What?
was?
The intention was to say the following in the chambers, that whatever played itself before this long adjournment or short break, is that as the defense of accused 1 to 4, we are of the strong view that the justice will not be dispensed with for the accused 1 to 4, because the counsel or the defense of accused 1 to 4 has been excluded to these proceedings, to extend that the court will tell the counsel of accused 1 to 4, sit down, like the court is talking to somebody who doesn't understand himself, for which, as the counsel, as the lawyer, I respect the ethics of this profession. And it is incumbent upon me, or is demanded by the ethics of the profession, to pay due diligence to my client. When the court is doing everything in its power to mute me unreasonably, when I have to make the submission that I be told to sit down, I be confined to certain decision that is not of mine, that I won't be part of that, just to make a rubber stamp the decision that is, which is so adverse against my client. It's unethical. And the rules and the ethics of my practice, or this profession, the honorable profession that I chose, and I've made an oath that I'll abide by the rules, by the ethics of the practice to the end. The main buzzword is paying due diligence. The maxim in the profession of law says justice delayed is justice denied. I feel strongly, to the extent that as a human being, when I'm of the conviction, and not just conviction, but a strong conviction, that the constitutional rights of my client are deliberately violated by the court that I expect to be impartial, the court that I respect so much, the court that it is not my desire for its decorum to collapse. What it played itself here before the long adjournment in this court is definitely leading to the collapse of the decorum of this court. And that will be blamed to the same court. I know, and you know, Justice Maumela, the court has to respect the litigant, the counsel. That is the example that court has to lead by, so that the counsel can know that there is a respect. And the respect, Justice Maumela, is a reciprocal. It's not one-way street. It's a two-way, give and take. I have several times got instructions according to the way the client and my instructing attorney see this matter going, see the way things are going. Not today, some times ago, that We don't see that the justice is going to be dispensed to us. These are the client. What is the way forward? What is a better way? What is the remedy? We believe that Advocate Defo, the remedy is to give you instruction, recuse the court. And I've denied Justice Maumela. I've advised against that instruction to recuse you. Despite the fact that I see what is happening, despite the fact that they see, they are my bosses, they give me instructions. If I deny and I refuse the instruction, they will unemploy me and they will be reasonable. You have made it clear previously that we are deployee here. This city doesn't belong to us. I'm deployed by this accused 1 to 4. They need justice. You have been deployed by the judge president of this court division. Advocate Msholole has been deployed by accused number 5. Paloi has been deployed by Shamila Patoi. We are all deployees, you were right. But of late, you become guilty of what you suggested. At the end of the day, for me, when I have to make a humble submission on behalf of my client, you are saying to me, sit down. Like I'm this naughty boy. I may be a naughty boy, but not of this court. I deserve the respect from this court, as much as this court demands respect from me. So, if I cannot allow myself to be accomplice to the violation of the constitutional rights of my client and rubber stamp the decision that I'm not part of, there are pertinent issues that I wanted to raise and of material effect to the benefit of my client, to the benefit of the justice system in this country. I'm not here to make my own rules. I'm a deployee, as you said. Now you seem to go to be going against your own advice. Which is
you are repeating that point.
And you'll always say,
it's
I'm
about
repeating myself.
repetition.
Yes.
That's why we differ.
So,
you have told me more than 2 times about deployee, and that's when I come out to say, don't repeat. I tell you all the time, I have 2 ears. I hear you each time. If I don't hear you, I will say, please repeat. No need to repeat.
In progress of this, my standing or my address, that we needed to make an objection to the postponement and substantiate why, make a submissions. If we can be allowed the opportunity, as Msholole has been allowed opportunity, as our lawyer has been allowed opportunity. When the court come and make a ruling, after I would have made a submission, I'm not saying submission that I made, the court must take. I say, here, please hear me. Please hear 1 to 4. It's a humble cry. Hear us out, your lordship. Justice. Let the justice prevail. That's what my client are asking, nothing more. This is what we want to make, that we are requesting that the dates, as Mr. Baloyi has been addressed, we need to be given opportunity, it's my instruction that I should object any attempt of postponement this matter. in the best interest of justice and the fair trial. Section 35 of the Constitution is clear about the fair trial. That's my humble submission, Your Lordship, that we be given opportunity when we say we object to the postponement and we are ready to make submissions. Thank you. And can I proceed with my submissions?
No, I will have to hear the others.
Thank you.
Thank you, my lord. My lord, both dates are suitable to me. 15 to 16 September, 4 to 14 November, and I also agree with the end blocking 16 January to 16 March, my lord. (5 to 16 September). All three dates are suitable, my lord, as the court pleases.
There is the issue that there is an application that needs to be made now.
My lord, I am the one who have requested the postponement, my lord, when I found myself in a predicament of not being able to proceed with the cross-examination. My lord will recall that when I asked for the adjournment, there was a witness in the box, my lord. Which I still had to finish the cross-examination with, my lord. But because of the unforeseen events that took place or emanated on the 8th, which is the previous appearance, I was then interjected, my lord, from the line of questioning, of cross-examination. And I ask this court to give me a reasonable opportunity, my lord, to go through the docket and prepare the defense case in order to be able with the cross-examination that I'm still in. As a result, my lord, in terms of the criminal procedure, there is no application that can be brought whilst I'm still standing doing the cross-examination. And I seek that I be afforded such an opportunity until I finish with my cross-examination. Then the court can proceed to listen to any other possible application. Those are my submissions, my lord, as the court pleases.
As we please the court, Your Lordship.
I'm not listening to you now. I gave her the opportunity. He is also to speak.
No, I need to reply.
Then
I need to reply before, because I didn't say I want to bring application.
That's the problem. That's where the problem starts.
That's what I want to correct.
That's not the procedure I know. The procedure I know is that she has responded. He is going to respond. We are going to give you an opportunity.
I want to correct her before.
Now, because you are advocate, therefore, you want to speak now. That's where we differ. That's where we differ. And when we say don't speak now, we are showing you disrespect.
Your Lordship, I just want to correct my learned colleague. I think
No,
I'm allowed.
you will correct her when it is your time to speak. It is not your time. I have not recognized you to speak now. That's where we differ.
I don't have to leave it to to the state. I have to correct now.
No.
Because I didn't say.
I don't want to listen to you now, advocate, therefore. That's the issue. That's where we differ. I want to listen to him. That's the procedure I know to apply in court. You are bringing me a procedure which is foreign to me, and I'm refusing to take it.
If I say, Your Lordship, there is oversight on the part of the court. This court is a human being, is not infallible. I never said I want to bring application. I said I want to object to the postponement and I want to make submission, not application.
But I didn't
That's what I
recognize
wanted
you
to
to
correct.
speak now. I didn't recognize you to speak now. You don't just shoot up and speak. The court will give you an opportunity, and it will surely give you an opportunity. Each time you want to speak, and it's your time, you will speak. Not to interject before Advocate Baloyi says what he needs to tell me. And I told you are confusing me. I have to jump back to TEFO, jump back to TEFO, jump back to TEFO. That's not how it works. That's not how the procedure works.
Your Lordship, is it allowed when, as myself, at the council of 1 to 4, if I believe that I've been misinterpreted by the court, am I not allowed to correct the court?
You are allowed to correct the court when your time comes.
There is sometimes
Not when you feel it's your time. No. When we go according to the procedures followed in courts of law, where we give people the opportunity to speak, and then because you started with this, you will be given an opportunity to reply. That's how it works.
I definitely understand, Your Lordship, that you and I, we are coming from the different school of law. That's where we'll clash. And you have agreed that it's allowed in the law that you know. If the court has misinterpreted you, myself as a 1 to 4, that I will never said I want to bring application. I said I'm humbly requesting this court to make submission based on my objection of the postponement. Thank you.
Advocate Baloyi.
My Lord, in the circumstances which have been fully canvassed regarding the disclosure of the second docket, the state has already indicated, my Lord, that we're not going to oppose the request of Advocate Mshololo.
Reply.
Thank you. Accused 1 to 4, Your Lordship, we are vehemently of the big interest to oppose the contemplated postponement in this matter. And we are hereby making submission as to opposition to the contemplated postponement, because it won't be in the interest of accused 1 to 4. It will not be in the interest of justice. As we say in the maxim of law, justice delayed is justice denied. Our submission in opposition are as follows. We came to realize a material defect which does not give this court a jurisdiction to hear and grant the application contemplated by Advocate Mshololo. The jurisdiction of this matter is a common cause that is under the local division South Gauteng in Johannesburg. And as we stand before this court, the procedure in terms of the Minister of Justice to give this court a jurisdiction has been grossly violated. Section 110 read with section 111 of the CPA, they've been violated. And here, I've got...
Section what?
Section 110. Section 110 is talking about when the accused have been brought before the court that does not have a jurisdiction. Read with section 11, treble 111, which is about the direction by the Minister of Justice to give the court that does not have initially, did not have a jurisdiction to hear a particular matter, in particular this matter of Sevilla and 4 others, State versus Sevilla and 4 others. Phosphorus case 636, 10/2014. And now here before this court is a Pretoria CC 67/2020. This court does not have a jurisdiction to entertain this case. It is therefore in the same spirit that the contemplated application of Advocate Mshololo is being brought at the wrong court. Therefore cannot be granted by this court. And that, if it has to, accuse 1 to 4, if feel aggrieved, we will have to bring the application, or we will have to bring the review or the appeal against. I know this court has not yet ruled as to that application will be granted or not. But in case it has been granted, our grounds of review or ground of appeal will be based on the fact that the wrong court has granted postponement, which inherently was not supposed to have granted. We have, there is annex double A. It was handed before the court, Your Lordship. Can Your Lordship have that document in position? Because this is contemplated to be, it's read as follows. Direction in terms of section 22, subsection 3 of the National Prosecuting Authority Act 32 of 1998, read with section 111 of the Criminal Procedure Act, Act 51 of 1977. Close quote. I now read this document for record. Investigations of Phosphorus case 636 10/2014. Whereas I, Shamila Batoy, National Director of Public Prosecutions of the Republic of South Africa, deem it in the interest of the administration of justice that the offense of murder, read with section 51, subsection 1, as well as Schedule 2, Part 1 of the Criminal Law Amendment Act 105 of 1997, open quote, 1 count, close quote, allegedly committed at or near Phosphorus within the area of jurisdiction of the Director of Public Prosecutions, Gauteng Local Division of the High Court Johannesburg, be investigated and decided upon within the area of jurisdiction of the Acting Director of Public Prosecutions, Gauteng Provincial Division of the High Court, Pretoria, I therefore hereby direct that the investigations in respect of the aforementioned matter be commenced and concluded for purposes of decision-making in the area of jurisdiction of the Acting Director of Public Prosecutions, Gauteng Provincial Division of the High Court, Pretoria, given under my hand at Pretoria on this 9th day of February 2020. That's the day when the burglary happened at Palapala Farm. It was on Sunday. Signed by Advocate S. Patoi, National Director of Public Prosecutions, the Republic of South Africa. Close quote. I, in confidence, take this honorable court in terms of section 110 of the Criminal Procedure Act 51 of 1977. I was still young by then. The provisions of section 110 of the CPA 51 of 1977 reads as follows. Subsection 1. Where an accused does not plead that the court has no jurisdiction and it at any stage, paragraph A, after accused has pleaded a plea of guilty or of not guilty, or paragraph B, where the accused has pleaded any other plea and the court has determined such plea against the accused, appears that the court in question does not have jurisdiction. The court shall, for the purposes of this act, be deemed to have jurisdiction in respect of the offenses in question. Subsection 2 of section 110. Where an accused pleads that the court in question has no jurisdiction and the plea is upheld, the court shall adjourn the case to the court having jurisdiction. Close quote. This is section 110, where of the concern, your lordship, naturally, and as some stage, I had my learned colleague, Advocate Mshololo, raising that we could have pleaded other way around. Should I have knew about the contents of 375? So here, that's where I'm supporting her. I mean, the section 110 is supporting her averment that where an accused, then the court shall adjourn the case to the court of having jurisdiction. And read with the provisions of section 111 of the CPA 51 of 1977 reads as follows. This is in relation to 111 as it has been depicted on the on Annexure AA that is purported to be read with section 22 subsection 3 of the NPA Act 32 of 1998. And that's where we say here there is a violation of the provisions of section 111 by the DPP or minister himself. And then, subsection 1 of 111 reads as follows. Where the minister deems it in the interest of the administration of justice that an offense committed within the area of jurisdiction of one Attorney General. In this regard, because we haven't changed our statute, we are now NDPP. Be tried within the area of jurisdiction of another Attorney General. He may, in writing, direct that criminal proceedings in respect of such offense be commenced in a court at a place within the area of jurisdiction of such other Attorney General. Subsection 2. Subsection 2A. The direction of the minister shall set out the name of the accused, the relevant offense, the place at which, open bracket, if known, close bracket, and the provincial division in which the offense was committed, and the place at which the relevant criminal proceedings shall commence, and the provincial division in which such place is situated. Paragraph B of subsection 2. A copy of the direction shall be served on the accused, and the original thereof shall, save as is provided in subsection 4, be handed in at the court in which the proceedings are to commence. Close. Subsection 3 of Table 1. The court in which the proceedings commence shall have jurisdiction to act with regard to the offense in question of such court. Subsection 4. Where the minister issues a direction under subsection 1 after an accused has already appeared in a court, the original of such direction shall be handed in at the relevant proceedings and attached to the record of the proceedings, and the court in question shall, paragraph A, where the accused is not in custody, cause the accused to be brought before it, and when the accused is before it, adjourn the proceedings to a time and date and to the court in which the accused is to appear in accordance with the said direction. Paragraph B. Forward a copy of the record of the proceedings to the court in which the accused is to appear, and that court shall receive such copy and continue with the proceedings against the accused, as if such proceedings had commenced before it. Subsection 5. The direction of the minister shall be final and not subject to appeal to any court. Close quote. That is the provisions of section 111 of the CPA, Your Lordship. Then I come back to Annexure AA. Number 1, violation of the jurisdiction. This document is purported to be the third direction by the minister. And this direction is not signed by the minister. This direction is signed by the National Director of Public Prosecutions. And furthermore, the purpose is not even centimeter next to the provision of Table 1. The purpose of this document, AA. Because this, it is clear, unless Advocate Baloyi can prove me otherwise. It's talking about the investigation of Phosphorus Cars 636-10-2014. And when I look at the signature, not the signature per se, but it was signed, it says, given under my hand at Pretoria on the 9th day of February 2020. And the signature is purported to be that one of Advocate Shamila Batoy, whom we know is the NDPP. And in terms of section 22, subsection 3, yes, can give the direction in terms of as to where the alleged offense can be investigated. She's got that power to investigate, not for the matter to be heard by the court. By the court is the minister. So there's no more where minister is appearing here. And then, furthermore, the revelations of this document It was signed on the 9th of February, 2020. We checked the calendar that the 9th of February 2020 was Sunday. And the day that we believe our Honorable Shamila Batoy is off, at home with their children.
9th of February, what year?
2020. If it wasn't because of Julius Malema reading the conference that the butler at Palapala was on the 9th of February 2020, I wouldn't be aware. Furthermore, Your Lordship, we are so very much doubtful that unless we can be proven otherwise, because we are doubting even the signature that purporting to be of the NDPP. Unless we can be proven wrong. And the only authority that can prove us wrong is the police investigation in terms of the document, question document. And even Ms. Batoy herself. We are of the strong view that she should be called and come in the box there and tell and confirm or corroborate this document. And another revelation or the mystery, Your Lordship, is that when this document was signed on the 9th of February 2020, these 5 accused, yeah, five accused. And I say deliberately 5 accused because there are 5 accused. I'm just saying, in case I want to be reprimanded, that don't talk about accused number 5. But it's accused before this court. And I believe it's also before this court. In the manner that if 1 to 4 are not in the manner that is proper, it applies to him. And we could not have been furnished let me saying deliberately or reluctantly, given the reasonable reasons why this matter is before you, Your Lordship, in Pretoria. No reason at all. That's where we mooted that we would love if our Honorable Shamila Batoy can come and sit in that box and corroborate or deny. We so wish. It's our humble request that will follow and will substantiate why. So, what I'm saying, Your Lordship, when I say on the 9th of February 2020, whoever was the investigating officer in South African Police Service under 636/10/2014, this will, by extension, goes to my learned colleague on my right hand, Honorable Advocate Baloyi, George by the name. Was aware that accused were arrested. So, the first time the accused appeared before the court, it was in Boksburg on the 27th of October, 2020. As we were informed by the Honorable Minister of the Police, Mr. Krele, that during the press conference of the 26th of October 2020, the South African Police Service's breakthrough on the murder of Senzo Meyiwa, the Bafana Bafana and Orlando Pirates keeper, It was 9 months before my client were arrested. How on earth, Your Lordship, with a due respect, can this purport to be the certificate of giving you the inheritance of this matter? How on earth can you assume, can this honorable court assume the jurisdiction pre-hearing? Yes. So there was somebody, I don't know if Honorable Advocate Patoy is a practicing gogo, the Sangoma. 9 months can contemplate that this matter will be here. What about the minister? It's not for Advocate Patoy. As we have just went through the provisions of Treble 1, that the directions and the jurisdiction will only be given to particular court. I mean, the jurisdiction will be given to a particular court by the Minister of Justice, provided it is in the interest of administration of justice. So now, not Shamla Bato, as I said, she can only say, all right, the police, together with my deputy director, or together with my senior prosecutor, maybe in this case we talk about my learned colleague, Advocate Waloi. Let's agree that the matter being investigated under the DPP Mzinyati in Pretoria. So, and then it's been taken from the DPP Mr. Chauke in Johannesburg. So, in essence, we can consider this annexure AA to be internal communication in the NPA. It's not the direction by the minister to give it this court a jurisdiction. My learned colleague will reply and can also prove us wrong or give us the relevant documentation, because it was his submission before this court that this is indication that this court can inherit or can entertain this matter. Which this was preached 9 months before our client were arrested, as I said. So, Your Lordship, therefore, we submit that SRQs 1 to 4, whichever is the contemplated application before this court, and whatever has happened before this court in terms of Sergeant Musia giving the evidence in chief, and I cross-examined him, and my learned colleague, Advocate Msololo, cross-examined him, and she is still of desire that she must continue cross-examine Musia in terms of the contents of Phosphorus Cast 375 01 2019, for which, Your Lordship, that content of that docket, which is not before this court, They've got nothing to do with Msia. And now it doesn't matter. It doesn't matter whether my learned colleague, Advocate Mushololo, is still having that aspiration or desire to continue with the cross-examination of Msia, because it doesn't matter anymore. What we had, what she had, she had. It's a prequental, she's saying that. Whatever we had, we had. It doesn't matter. And it is in this spirit, Your Lordship, and I would love to say thank you very much for affording me this opportunity to support the opposition of the postponement requested by my learned colleague, Advocate Mushololo. And last but not least, which is very of important, because if indeed it will be found that this court does not have a jurisdiction, the game will change. Of the West, we will consider that our client have been kidnapped from Johannesburg to be brought here and tried against their will before this court. And we will deny that our client be prosecuted by the court that does not have a jurisdiction. However, because the court is the court, it's got the power, can make a ruling. If this court make a ruling that no, despite the fact that you see what you are reading, then it will lead us somewhere. However, I now, as I say, this proceedings before this court, as contemplated by the provision of section 111 of CPA, saying only if it's in the interest of administration of justice, the minister can afford a particular court a jurisdiction. But whereby the minister didn't afford that court such a jurisdiction, and we have the client here. In my case, I've represented accused 1 to 4. Accused 1 and 2, when they were arrested outside. They were not serving any sentence in any court. I've got accused 3 and 4 who were serving sentence, and they were in the process. When they were alleged of this Meyiwa matter, they were in the process of appealing the conviction and the sentence of those matters. Accused number 3 was in Johannesburg prison, and accused number 4 was in Leeuwkop. But I stand to be corrected. May I approach accused number 4?
Yes.
Thanks for indulging, Your Lordship. I was right. Accused number 4 The J7 was signed by that honorable court that gave him the sentence to go and serve at Leeuwkop, which is a jurisdiction of Johannesburg. And I was also correct with the accused number 3. The J7 was signed by that honorable court giving the sentence to serve at Johannesburg prison. And 1 and 2 were just arrested outside. So, if the procedure has to be followed in this regard.
So according to you, the implications of them having been arrested when they were outside, what are those implications?
1 and 2.
Yes.
Yes. The implication is that, as per the provisions of section 110, that says, if the accused insists that we are at the wrong court, then from here, the court has to adjourn, and they, because this court does not have a jurisdiction, this court today cannot say to them, you are remanded in custody. They just leave, they go home from here. Yes. It cannot be this court saying, you are in custody.
So if a person is outside when they are arrested, when they appear in court, they should be told to go home.
Let me say this. The court, somewhere in Boksburg,
Yes.
that sent them to court. That sent them to prison. Because one is now in Modabin Binoni. And then one...
No, you are not replying.
No, I want to study there because it's a history. I want to say...
But whatever you say by way of history, my question will still be one at the end of the whole story.
Okay.
You are saying whoever is arrested while they are outside, when they appear, the day they appear in court, they should be told to go home.
What I wanted to say before Your Lordship interject, I wanted to say the court somewhere, the court that signed J7 for them to go to prison, while they were naturally not in prison, not serving any sentence, it was misled by the Honorable Advocate Baloyi. That court was misled. And at no stage, there was even an attempt. Actually, 1 and 2, they've been in custody without a trial. Because we did consult. At no stage, there was never any attempt after they were arrested, so-called arrested in June. They were never taken to any court within 48 hours to apply for a bail, and they be given a bail if it is in the best interest of justice. So their situation was like that of pre-1994, apartheid system whereby there will be detention without a trial. That's what they have suffered up to today.
Yeah, I don't want to enter into
further.
an argument with you about without trial, because I thought we are in a trial.
Before the 22nd of April, Your Lordship. And then to further make submission as to what are the consequences, Your Lordship, I say further that the implications is that as at one stage I made an attempt previously in terms of the special plea. The implication is that accused 1 and 2 are unlawfully arrested, and that is in violation of their constitutional rights. In terms of Section 85.
Unlawfully arrested or detained, or both?
Unlawfully. They are unlawfully arrested and unlawfully in detention. And that was unlawful after 48 hours, somewhere in June 2020. After 48 hours, they were still kept at the police stations, various police stations. So that arrest after 48 hours became unlawful arrest and detention, which persisted until the 22nd of April when they pleaded not guilty. So I shudder to think about the consequences of postponement to September. Let alone September. Even if it could be said to Your Lordship that we postpone overnight, the violation of their constitutional rights in terms of unlawful arrest and detention is continuation. Because, like I said, that is that perpetual detention without a trial. Yes, Your Lordship has said, yeah, we are just giving the benefit of doubt, now they are on trial, but they are late anyway. It doesn't matter now whether we are in trial or not. And that matters making to us is that when they believe to be before the court that is not, should not have inherited the jurisdiction to try them. We may not disagree. In case we may not disagree, or in case this honorable court, despite the reason I've mentioned, we say no. The contemplated postponement by Mshololo should continue. We will humbly then, if it's like that, court would have said, the court has spoken. However, we'll follow the right procedure. And as long as we might have said, and it will be humble request that those people in terms of provisions of 110 and read with treble one, they have to be asked to go home as contemplated, and the court seek for the right, and the parties negotiate if that is in the interest of justice, administrative justice, which court is the relevant court. And is the reason today, Your Lordship, in closure. We are in a catch-22 situation of two dockets. So, therefore, I say, these accused are before this court in terms of 636, not 375. 375, as it has been said, it will inherit the jurisdiction in Johannesburg, where we are of the strong conviction that the suspected people contemplated in Exhibit C are the one who's supposed to be before the court, and our client should be vindicated. More so, and I need Advocate Baloy to listen carefully to this point, which is very, very, very important. More so when they were arrested. First Laura's case, 636, 10, 2014. At the time of their arrest, it was quashed. What does quash mean? That docket was dormant. It was quashed after unlawful arrest of one Mr. Zama Kutembat. Nonetheless, there has been another attempt now. This time, as if it was not enough to arrest one person, Zama Kutembat, the state said, no, we need 5. Zama Kutembat alone was not enough. So, it is in a relevant authority, Your Lordship, that docket 636, when the accused were arrested, it was quashed because of unlawful arrest, the first unlawful arrest. Therefore, insofar as the conundrum of due docket is concerned, Your Lordship, and as I've indicated that Exhibit C and D were brought before this Honorable Court by accused 1 to 4 in order to indicate that there is a relevant docket that must be entertained, but not by this court, but another court, which is in the south. This is our submission, Your Lordship, and then we'll hear from the Honorable State. Thank you.
This morning, Advocate, therefore, in my view, was in an attempt to bulldoze his way, procedure-wise, in as far as this proceedings are concerned. The court would have none of that, and I'll address it briefly. And the court did not go the route. Advocate therefore was forcing it to go for reasons that I shall explain. In due time, when his time came, Advocate therefore has addressed this court at length, an opportunity which was always at his disposal all the time when he was trying to bulldoze this court into a procedure which comes foreign to it. He mentions aspect of ethics, and my view is very dim in terms of his adherence to ethics. In court, what obtains is that if you present something and the court overrules you, that is the end of the matter, albeit a temporary end, because if injustice is brought to bear due to being overruled, it becomes a matter or a point for later on review or on appeal. But what is surprising, and it continues to surprise me, is that whenever Advocate therefore is overruled on any matter whatsoever. If you succeed after a long struggle to get him not to proceed, the next time you proceed, you give him an opportunity to address something else, however unrelated. He will go back to an issue on which the court has already given a ruling. Yet he purports to be a proponent of ethics. There are issues, and I think he would be entitled to raise them, where he feels that before I go there, he harps on the issue of respect. And respect is when, or disrespect to him is when, after being warned and overruled by court several times, he insists on proceeding on the same issue about which the court has already given a ruling. And if you don't grant him his way, then you are not respecting him. And I don't know what that says about his respect for the rule. The court is well vulnerable to erring in any ruling. I do not think the court should think of itself as a whiz kid on any matter. It will err from time to time. And in our system, there's a way of dealing with instances where the court errs, instead of adopting a no masafa attitude. We note where the court brought injustice to bear by way of ruling wrongly, and we deal with it according to the law. And that is a measure in place to ensure decorum in our courts of law. And I want to repeat, I am subject to erring. Whoever will go and look at my work will find that other courts have corrected me from time to time, as will happen with any judicial officer. The aspect which was pricky is that Advocate Mshololo is on the forum presenting a matter towards a particular direction, something that started in the absence of Advocate therefore. And when he comes, his approach is as if Advocate Mshololo is not on the podium presenting a matter. And that is where we found our differences, and that is where he found cause to accuse the court of disrespect. And he is right to say he cannot be expected to rubber stamp, and he claims that he is not bringing his own rules. But I must say that I am yet to read the rules Advocate therefore operates upon, and that is what gives me the jitters if I were to apply them the way he wants me from time to time to apply those rules. And I keep on saying the rules for court processes are written down in black and white, and court etiquette and court practice has ordained that in court a party will present a matter or an application, the counterparts will be given an opportunity in their turn to respond to what has been presented, and when they have done so, as happened this afternoon after a long struggle with Advocate Defo, the person who rose with the matter will be given an opportunity to reply. And in the reply, Advocate Defo brings issues that were not on the table of his counterparts, Advocate Mshololo and Advocate Baloyi. Partly he blames the court for having not given him the opportunity to bring those issues on the table. Maybe that is an argument for another day. However, whichever way you look at the presentation and the responses, some new issues, I don't know whether new is the word, but some issues for consideration have landed on the table of this court, which go to suggest that this matter is wrongly before this court. As I sit here, I have my views, but I'm not a party. I think it will be best to grant the opportunity to the parties concerned to respond to some pertinent issues before we proceed with this matter. Before I name those aspects, Advocate Mshololo, like any other defense counsel, wants time to go about preparation of the defense of her client, a right which should be available at her disposal and her client's disposal by virtue of the reading of the Constitution of this country. And therefore the court, I think it has been mentioned that if the court does not rule the way Advocate Defo prefers, then it should ready itself up for something coming by way of a review or whatever other legal process. Looking at the scenario, I have been told as I sat here that there's a day way in the past when Advocate Defo was favored with a copy of the so-called second docket. It is therefore understandable that Advocate Defo is at home with issues from the second docket. That is why he was able to articulate on some of them this afternoon. But that is not the case for Advocate Mshololo. It is not the case for Advocate Baloyi, who both claim that this docket, which Advocate Defo had all the time, was given to them at a later stage. The case for Advocate Baloyi may be questionable, as Advocate Defo raised it, but there is no denying that Advocate Mshololo was not favored with a copy of the second docket at an appropriate time, and this is what is bringing the delays we are experiencing. And in respect of the rights of accused number 5, the court will be very inclined to a reasonable or to a postponement over a reasonable period of time. Whilst Advocate Mshololo goes over what has been recently discovered to her, and whilst she considers her options, of which she has already mentioned that it may include further consultation with her client, and where she also mentioned that she cannot rule out a particular application coming the way of this courtroom. The court has identified certain aspects that have to be put into perspective. And having said that, it may require that all that Advocate Tefo was mentioning before court this afternoon be reduced into heads, to which everybody concerned shall respond, so that in between the time Advocate Mshololo will be going the route she has mooted, something unfolds that brings clarity and a way forward regarding the aspects I'm about to mention. And it may well be more of a baby for the purposes of Advocate Baloyi. The first point is that the minister did not sign. Like I said, I have my views, but I'm not a party. The minister did not sign the relevant document. The DPP, in the person of Advocate Shamila Batoyi, signed. We may require a pointed response to that aspect. Secondly, that even if Advocate Shamila Batoyi signed a relevant document, its reading suggests that she signed on a Sunday, where she was supposed to have to be home and not in an office. Like I said, I have my own view. I have signed documents on any day of the week, but I'm not a party. Thirdly, accused number 1 and 2 were outside when they were arrested. I tried to pursue this with Advocate. Therefore, I didn't get a pointed answer, but I have come to perceive his reasoning to be that in this case, because they were outside when they were arrested, after their first court appearance, they should have been allowed to go home. Alternatively, because he doesn't put it in so many words, alternatively, that Advocate therefore has issues with the fact that after the initial arrest, accused number 1 and 2 were not made to appear before a court of law within the ordained period of time, which is 48 hours. And thirdly, which points to Advocate Baloyi, that when accused number 1 and 2 appeared for the first time before court and their case was postponed with them in custody, that happened because Advocate Baloyi misled the court. I had questions on this one, which I decided not to ask because it would border towards me making myself a party on these matters. These are the issues that came through as more pointed among others, as advocate therefore addressed court. And my suggestion is that we find a way of addressing them. Whilst we have had Advocate Mshololo indicating that she needs time to do 1, 2, 3, which I will not repeat, it will be wise of us to deal with these issues, whether it includes calling people before court that are not here or having their affidavits, but that should all be captured in heads that the court shall study and make a ruling. And something pleased me this afternoon, where for the first time in some bit of long time, I heard Advocate therefore saying, were the court to rule out of or to rule not in tandem with his aspirations, he contemplates or reserves his right to launch a further legal process. And that is how lawyers respond to anything that courts rightly or wrongly pronounce. So, because we had a date about what Advocate Mshololo had or thought of doing, I think we should have a nearer date in order to address this. I must be well understood. I'm not ordering anybody to do or to come to court who feels that they are not supposed to be before court. All I need is for these issues to be addressed, whether by way of getting some people to come who are not here, or by way of submitting affidavits that will bring the court up to speed regarding the issues raised. My strong view is that the terrain is not all that flat to just blindly proceed with this matter, with these serious issues. Lest I find myself with serious egg on face at a later stage with these issues having been raised. For now, these issues may or may not be founded, but it is better to arrive at a decision rather than to land there without consciously deciding. Because for me, it determines whether we are on the correct train in terms of proceedings in this case. And it brings to mind a quotation by Bonhoeffer, which says, once you board a train, once you board the wrong train, it doesn't matter how fast you run to the opposite direction. That train will still take you to where it is going. So for that, I would that we find a date where Advocate Baloyi thinks he will be ready with these issues, because I presumed that the manner these issues came out, it may be that Advocate Mshololo and Advocate Baloyi are not prepared for all the issues that were raised. But if they were, my issue is that they reduce their responses into heads.
As a court, please, my lord. can I make a suggestion?
Yes.
Would it not have been perhaps better for Advocate Tifol to bring a substantive application and then reducing his arguments to writing?
Yeah.
And we can agree on a timetable, then we can respond to that. Because one of the issues that he raises, the reasons why jurisdiction was transferred, and one is not always sure as to exactly what are all those issues. So at least if they are in a written form, we can then address those issues pertinently, my lord.
Yeah, well, it is exactly why I myself cannot rule towards any direction after his presentation, because it did not come clear, which I think will not be the case if it were to be captured into heads.
Yes.
It is again why I am saying that we should have heads, so that we have something formal
Yes.
to which all can respond formally,
Yes, indeed. my lord.
and about which court can pronounce formally.
Yes, and about which there will be no doubt, as
Yes,
unlike it is at the moment.
yes.
Sorry, I again trying to demote you, Your Lordship. I'm amenable to, but I'm just only opponent of substantial, because I've learned to know and understand when Advocate Baloyi says substantial, there is something that is launching for. Something will be brought here relevantly so, and then the so-called substantial, because substantial is sublinear to me. It's like, as I know him, that is a font of guerrilla warfare style to ambush. I'm unable to bring submission in writing as per instruction, and then on that issue
Are you not launching an application?
Pardon?
Is this not an application on your part?
No, I was just responding to him.
Yeah,
This-
I'm saying, if it is an application,
Yes.
there's only one way of launching an application. It has to be substantial to be entertained.
Yeah.
About the booby traps Advocate Baloyi is capable of.
yeah.
You are a soldier, you'll see how to diffuse
Yeah.
those booby traps. We cannot forsake a known procedure just because we are afraid of booby traps.
Yeah, I would just like to remind the Honorable Court that he's just not coming to me, like I'm just me. No resources. Remember, you come with the state resources. So that's what is very important for the court to be aware of. However, I'm saying that in terms of what the court mentioned, in case I heard the Honorable Court says, if there would be the people that had to come here, or the affidavit. We are dealing with the criminal proceedings here, Your Lordship. So if there will be any affidavit, it has to be followed by the author. Because I don't think we will, I just wish and I just pray that somebody should not depose an affidavit and thereafter the person become permanently absent on earth, whereby we'll have to go and try to bring the application in terms of the provisions of Section 3 of the Law of Evidence Amendment Act. So it's a natural that once there is an affidavit, then it has to be come and corroborated by the author. Like I said, unless the natural volition has taken place, someone is absent forever. So, and then I do understand giving the benefit of doubt, this predicament, it will be supported or substantially be brought as per the instruction. As it please the court, Your Lordship. Okay, and further to that, there was overlooking or oversight, but was not deliberately on the side of the court, that insofar as the accused are concerned, 1 and 2, because it will be injustice if we have to agree on the date for which is a procedural to say on this date the court will put us in tender, hold us in terms to say the counsel for accused 1 to 4 bring your substantive application on this date and serve the state, serve Mushololo, and then if there is a reply or answering, because those will be the allegations. And the learned court will teach me here, because I'm still very much learning, Your Lordship. We depend on you for the guidance, because you have seen a lot of things before we see them. You're a father, you're a grandpa. Insofar as holding us in terms, say from today, in 3 days, defense for 1 to 4, bring your substantial application in relation to the jurisdiction. And then, in 48 hours or in 2 days, advocate the state, answer those allegations. And then, when I say I need a guidance from this honorable court, I don't know what to say to Advocate Mushololo, because she's my fellow defense. And it seems as if now the defense is not united. And as you can know, Your Lordship, that...
Yeah, let me request you to address me. Leave her alone. She's running, she's...
Parallel.
Yeah, no. You told us this afternoon that you are afraid that your clients will unemploy you.
Okay, yes.
Yeah. Now, don't push her to be unemployed by a client.
Okay.
Let her independently run the defense of her client.
Thank you, Lordship. So the guidance that in between or in the meantime, yes, I'm of the support of the expeditious hearing of this matter, as it is material, where it will put my client, accused 1, 2, 3. Why accused 1, 2, 3? Accused 1, 2, 3, as I said, that if there is any postponement today, as we postpone, obviously we are not going to sleep here, and I don't foresee that I will get the answer today.
Yeah.
What will put
Maybe
my
I should give you a quick answer to that one.
Yes.
Similar to an answer I have already given you in some other unrelated issue in this very trial. In our legal system, one of the things we do is to apply the rules of natural justice.
Yes.
And a rule of natural justice that is relevant, that comes to point here as you are saying what you are saying, is that is one that says Audi.
Partam.
I don't know whether it's called what you are saying. But in English it goes here the other side.
Yes.
Yeah. And now I do not think your clients woke up one day and decided to walk to a prison. Somebody took them to a prison or into incarceration. And
I agree.
You are now saying they should be allowed to go home before we hear from the person who put them where they are. And the court is not likely to do that, simply because it has to respect that rule of natural justice. In the process that you are demanding, the process, the pace of which you demand should be a fast one. I think that rule will be accommodated. Because I don't think we will have a situation where people are arrested and they go to court, somebody who did not arrest them but is merely assigned to hear their case decides that they are going home. There might be some things we don't know, I don't know. So I will be more comfortable if I hear from the quarters that ensured that they be incarcerated.
Yes, but I know.
Yeah, I don't know.
Yes, I agree.
Yeah. The difference between me and you is that I don't know, and until they come, I don't know.
No, this is reasonable, Your Lordship. So the process can be that one of expeditious in terms of intent.
Advocate Mshololo and Advocate Baloyi, I agree full square with Advocate, therefore, that for this aside issue, we really need maximum speed, lest we continue to undermine the rights of I would agree with him and say of everyone, including your client. So, but I wouldn't put it in terms that he put it, that he gave himself more time. And when you have to address those many issues that he was addressing about, he gave you 48 hours. I think I wouldn't go along with that. But I think reasonably we should be at a fast pace in dealing with this matter.
I think, my lord, that can be arranged amongst the councils,
Yes.
regarding the time frames for the exchange of the documents,
Yeah.
as the court pleases.
Advocate Baloyi?
Indeed, we are agreeable to a timetable for the exchange of papers. The only question, my lord, that remains is the date to which the case must then be postponed.
Yeah, I'm saying because it's a you determine. This is a criminal matter. In criminal matters, we are used to having the accused before court when we deal with those cases, and it would seem much as it won't assist the process we are talking about. I don't see any reason for not requiring them to appear when issues will be, especially when we are also touching on issues of
Jurisdiction.
of jurisdiction and issues of incarceration or being let out. But I do not think for the immediate foreseeable future when there shall be submission, I don't think we need them here, and I don't even think we need you here. I would think that there will be an interaction between the parties regarding the heads, and when those heads are argued, that is when we will determine that they be before court. And that is why I asked what would be the most immediate date we gather here for this matter. I would even go as far as to say that for that purpose, I would importune all of you to even venture into recess time, so that we find a day to deal with those heads, which will then give me an opportunity to find time to come up with a response to the submissions you will have made.
Yeah, as the court pleases, my lord, I think that would mean we still need to consult with the role planners. One cannot just postpone a case without their consultation, because, I suppose the JP also, seeing that this is a partly head matter, there also has got to be a consultation with the.
We are way over our time, and as for the one going to Kosimampuru, you you may even say now that person will not have supper, which is unfair.
Yes.
Should we not postpone overnight and deal with that aspect? Consult the role planner and everything so that we come with an informed view tomorrow.
This in order.
Advocate, therefore, you are excluding yourself.
Tomorrow.
No, I'm saying, I asked the question, the rest have given an answer, you didn't. I say you
Yes.
are excluding yourself.
We postpone this matter overnight.
Yes.
That's correct. Court, please insert. Yes.
Please rise.
Before we adjourn this matter, I think I should bring it to the attention of the court to say it is wrong for the interpretation not to be done to the accused because they do not understand what has been exchanged before this court. Even,
Yeah.
I'm not saying it must be done now, but it is wrong that interpretation is not done.
Yeah, I'm asking myself if I were an interpreter, when would I have?
Thank you, madam.
When would, yeah, all you may do is to remind us that tomorrow, either formally or informally, an interpretation should precede whatever happens.
Okay. Thank you, my lord.
Sorry, my lord. It's not that. I was taking notes. I got the
No,
notes.
no, no, I
It
know.
will take us until tomorrow.
I know, that's why I'm saying, from the interactions, I don't know when you would have interpreted all that. So with the accused in custody, this case is postponed by agreement overnight in order to determine the way forward in the manner explained. I think we start at 10 as usual with this matter.
So, Father, again, we'll tell you, Sasa, the fate.
It is again a reality that we would not expect Mr. Musia to be here. It is again our reality that what he warned against may be well nigh if things go the way he contemplated. So we should also be thinking around that.
At the court, please, sir.